Hello, everybody.
Okay, I can't see all of you, Mr. Crane.
You can see me?
Now I can see. That's better. All right. This is in the District Court of Ellis County, Kansas. Case number 24 CR 197, State of Kansas versus Caleb Crane. May I have an announcement of appearances, please?
Please, the court. The state appears through Assistant Ellis County Attorney Joshua Becker. Caleb Crane appears on Zoom pro se.
And you are Caleb Crane?
Correct.
Okay, your box says Jerome Crane.
That's my middle name.
Okay. And following our hearing on January 3rd, we are scheduled today for a motion to suppress, correct?
Yes, Your Honor.
Your Honor, for the record, can you please state the title of that motion and the certified mail number for me? I just need to clarify.
I don't understand what you mean by certified mail number.
Well, I file all my motions through a certified mail number. Like I have one in front of me from a phone right here with a file stamp on it, and I have a certified mail number that I filed through the court with the tracking number 9589071052701868199070. And I was just trying to make sure that you got the right motion.
You had filed a motion to dismiss in this matter back on
I believe November 12th, Your Honor.
November 12th of 2024.
Yes, I filed that motion, and that motion was never heard by the court.
Okay. We had gone through the motion and you had identified this by what you put down as quote counts.
I would like
You had count 1 regarding identity fraud. And
Yeah,
you had count 2 dismissed due to illegal search and seizure. And that's what we're hearing today. And you had count 3 speeding infraction should be dismissed.
the prosecution failed to respond to the motion, and the court never heard it though.
Well, they did respond to it in arguments on January 3rd.
And as well, I filed if I may, Your Honor, I filed my response to his motion on December 6th of 2024. We had sent that by mail and by email to Mr. Crane, or at least to the address and email we had on, excuse me, on file here in our office for Mr. Crane.
Can I get that motion read on the record, just to clarify?
Well, I'm not going to read your entire 62-page motion onto the record, Mr. Crane. The record is the record, and it is filed as of November 12th. We dealt with what you called count 1 and what you called count 3 last time. What you have as your second issue, what you're calling count 2, is that the possession of the controlled substance should be dismissed due to an illegal search and seizure of the contraband, which the court inquired of you if you were actually filing a motion to suppress the evidence based on illegal seizure, and you agreed that's what you were intending to do.
I'm not withdrawing any of my motions, Your Honor.
Okay. I'm not asking you to withdraw the motion.
No,
I'm
I was
asking
just saying
you.
I'm not withdrawing any of my motions. I was just letting you know.
I understand that. But your count 2, you're alleging should be dismissed due to an illegal search and seizure,
Right.
which is a motion to suppress evidence.
No,
And that's what we're here to do, is have the hearing on your motion to suppress that evidence.
and that's what I'm saying. I never filed that motion, Your Honor. Every motion that I filed, I have with a certified mailing number. So I'm trying to see where are you getting that I filed a motion to suppress.
In count, what you label as count 2 of your motions document filed on November 12th, 2024. Page 2, you write count 2, possession of controlled substance should be dismissed due to an illegal search and seizure. Okay. Your motion to dismiss due to an illegal search and seizure is a motion to suppress the evidence based on an illegal search and seizure. That's what we're here today for an evidentiary hearing on. Your motion to dismiss based on an illegal search and seizure.
Okay,
That's what we're going forward on today.
but that's what I'm saying. I never said that. But could you speak to me in layman terms? Because I'm not understanding.
I'm speaking to you and then understand.
Can you hear me? It was breaking up.
Mr. Beckett.
Fred, your mic is doing something odd. It's
Yeah, I thought it was just me.
Hey, hang on just a minute. Mike, apparently my mic is breaking up again.
I hear it better now all of a sudden.
Okay? Can you hear me?
Yeah, we can hear you better now.
Apparently it breaks up from time to time and I don't know why.
Mike.
Okay?
So yeah, Your Honor,
Hang on just a minute.
no problem.
Can you hear me now?
Yes,
Okay, is that better?
yes.
Okay. You Be on the right microphone, it's going through your other deals.
Okay, let me know if there are audio issues. I've had some issues with this.
No
Okay?
problem.
Okay,
So
Mr.
yes, like I was saying, could you speak to me in layman terms? Because I'm not understanding.
Well, sir, those are as layman terms as it can be made. You have the obligation when you represent yourself to know the rules and to follow the rules, same as an attorney. Okay? You
How can-
filed your document on November 12th, 2024. What you're calling count 2, and you say, and I quote on page 2 at the bottom, count 2 of possession of controlled substance should be dismissed due to the illegal search and seizure of the alleged contraband. So what you're asking the court to do is to dismiss the charge of the contraband that was seized based on an illegal search and seizure. So
Yes,
you have filed a motion challenging the search and seizure. And that's
and
what
not
we're here to
to
hear
suppress
today.
evidence.
What's that?
And I said, and not to suppress evidence.
Well,
never
that's what
filed
your
that
motion is.
I never filed that motion.
Well, the
And I have,
motion to dismiss is based on you're asking the court to suppress the evidence based on an illegal search and seizure.
that's what I'm saying, Your Honor. I don't understand how I'm asking the court to suppress evidence if I filed a motion to dismiss an objection.
Well, that's what the motion to dismiss is. It's a motion to suppress the evidence. And if the state doesn't have evidence, then it gets dismissed.
Okay, Your Honor.
All right. Are you ready to proceed on your motion?
Did you get my other motion, me responding to the state to declare the appeal unlawful?
Yes.
Okay. Is that motion going to be heard on the record today?
Well, we'll deal with that. You filed it 2 days ago. We'll deal with that after the suppression hearing that we're scheduled to hear today.
Your Honor, if I may, on that motion, it's filed untimely. We've already determined the appeal at our prior hearing was unlawful, given the nature of interlocutory appeals and the defendant's right to an interlocutory appeal at the last hearing.
Well, again, counsel, let's deal with the motion that we're here to hear, the motion to suppress, then we'll take up other issues. Okay? So is the state ready to proceed on the motion to dismiss?
Yes, Your Honor.
Go ahead.
The state would call Trooper McCord.
Yes, sir.
Trooper McCord, will you raise your right hand? You solemnly swear and or affirm that you will tell the truth and the whole truth and nothing but the truth, subject to the penalties for perjury in the state of Kansas.
Yes.
Thank you.
Mr.
Mr. Crane, you understand we're doing this hearing today by Zoom
Correct.
at your request.
Correct.
And is it still your request to do this hearing by Zoom?
Correct.
Okay. Go ahead, Mr. Becker.
Could you state your name for the record, please?
James McCord,
And who are you employed by, Mr. McCord?
the Kansas Highway Patrol.
What is your job title there?
I am a Kansas State Trooper.
Okay. And what rank or designation do you have?
I am a technical trooper.
What do you do in your position as a technical trooper for the Highway Patrol?
My daily duties are to enforce traffic laws of the state of Kansas, and along with assigned to a domestic highway enforcement team, which goes after criminals traveling across our state using our roadways for illegal activities.
Okay. What kind of training have you received for your position at the Highway Patrol?
It started with a 20-week academy in January of 2002 when I was first employed with the Highway Patrol, then continuing minimum 40 hours every year.
As part of your training, have you been trained in the detection of controlled substances?
Yes, I have.
Okay. Does that training include detecting the odor of marijuana?
Yes.
What does that training look like? Do they like sit at a table in front of you and have you smell it? What do they do?
Well, it was during my initial training with the Highway Patrol. They introduced us to a lot of drugs. They identify like marijuana, cocaine, methamphetamines. They show us what it looks like, along with getting to be around the item where you can't smell it. In raw and burnt condition, I guess.
And so you're familiar with the smell of both raw and burnt marijuana?
Yes.
And as part of your training, have you been trained on legal standards like probable cause and reasonable suspicion?
Yes, I have.
Okay, what kind of training have you received on those like legal standards?
It's been numerous trainings. We just went through blue to gold training on search and seizure of vehicles, property, and persons just recently.
Okay. In your position as a technical trooper for the Highway Patrol, are you a certified law enforcement officer?
Yes, I am.
Okay. And have you been at all times since you've been employed a certified law enforcement officer?
Yes, I have.
Okay. And does that include on June 20th, 2024?
Yes.
So let's talk about who you know. Do you know Caleb Crane?
I had a traffic stop with Mr. Crane, yes.
How did you identify Mr. Crane at that traffic stop?
With a driver's license.
And Would you recognize him if you saw him?
Yes, I would.
Okay, is Caleb Crane on Zoom here today, whose Zoom box says Jerome Crane? Is that the same person you stopped on June 2024?
Yes.
Okay, what was the reason for that stop?
I'd stopped him for 80 miles an hour in a 60-mile-an-hour construction zone along I-70 at mile marker 157 here in Ellis County.
And what mile marker was that? Do you remember?
157.
What kind of car was it?
It was a black passenger car.
When you initiated that stop, what was your next step?
I made contact, and then at the window, I could smell the odor of marijuana coming from the vehicle.
Was that raw or burnt marijuana?
Raw marijuana.
Prior to that, let's back up a little bit. As you were approaching, did you observe anything inside the car?
Yes, I did. The passenger was digging around in the vehicle.
Okay. Is that unusual?
Yes.
What did that indicate to you?
Possible trying to use cover scent to hide narcotics in the vehicle or any illegal items that they didn't want me to see.
When you say cover the scent, what did you see that indicated that they were trying to cover the scent?
It appeared, in my perspective, that the passenger was spraying like an air freshener in the vehicle.
Okay. How strong? You had mentioned that you smelled the odor of raw marijuana. How strong was the odor?
It's an odor that you can it's very distinctive. I can't quantify. It's just the odor of marijuana.
Okay. Would you say it was a strong odor or something less than that, weak? What?
It would be a strong odor.
Okay, so going forward to when you interact with Mr. Crane, what did you do once you started to interact with him?
I asked for his driver's license, proof of insurance, and registration paperwork. And at that point, they advised the car was a rental.
Okay. And so did they provide you with the driver's license and registration?
Yes, they did. The driver and the passenger both identified themselves with the driver's license.
Okay.
And the passenger advised his brother rented the car and they did not have the rental agreement.
Okay. Where was the registration?
In the glove box.
Okay. When they opened the glove box, did you observe anything?
Yes, I did.
What was that?
I observed a medical marijuana package.
Okay. What did you believe? What, if anything, did that mean to you that there was a medical marijuana dispensary bag in the vehicle?
That there would be marijuana in the vehicle.
Okay. So going forward from there, once you've obtained their driver's license and registration, what'd you do after that?
I returned to my patrol car.
Okay.
And then I had our Kansas Highway Patrol dispatch run both driver's licenses along with criminal history. Then I radioed for my partner to return as he just drove by westbound, come to my location.
Why did you call him back to your location?
Because I had probable cause to do a search of the vehicle and there were two subjects in the car.
What factors at the scene kind of played into your probable cause determination that there was marijuana in the vehicle?
The odor of marijuana, then seeing a dispensary package in the glove box.
And at any point, did you see the car driven by Caleb Crane moving?
Yes, when it passed me in a stationary position.
Okay. How long before you conducted the search did you see it moving?
Yeah, approximately 4 or 5 minutes. That would be a guess.
Okay.
I wouldn't know the exact time.
Sure. At the time you searched, did you have any reason to believe the car could be immobile?
That the car could be mobile?
That the car was immobile, that it couldn't move?
Well, the car was still running at the time when I got him out of the vehicle.
Okay. Your Honor, I don't think I have any more questions. Thank you, Mr. McCord. Trooper McCord.
Mr. Crane, do you have any questions of Trooper McCord?
It was really just like weird to me though, but because he said it was an air
Objection, he's
freshener.
testifying.
Hang on, I let him finish and I can determine whether he's asking a question or not, Mr. Becker.
It was just weird because he said air freshener, then there's a strong odor of weed. It was just like, which one was it?
Okay, Mr. Crane, if you have questions of the officer, ask the questions.
Did you smell air freshener or did you smell marijuana, Trooper McCord?
I smelled both.
That's that's my only question.
Based on that question, Mr. Becker, do you have any redirect?
No, Your Honor.
Okay. Do you have any additional witnesses, Mr. Becker?
No, Your Honor.
Mr. Crane, do you have witnesses you'd like to put forth or evidence you'd like to put forth?
I wouldn't say evidence, but once again, one more question. I'm sorry about that. Trooper McCord, so if you've seen a medical marijuana bag in the glove department, how do you smell marijuana? Through the bag.
Because the car had marijuana in the vehicle. Marijuana is a very strong, distinct odor.
Okay. You can continue, Your Honor.
So do you have any witnesses you want to put forth, Mr.? Okay. Argument, Mr. Becker.
Yes, Your Honor. From the testimony today, we've heard Mr. Trooper McCord is a trained and certified law enforcement officer who's been trained in detecting controlled substances, including by their odor. He can detect the odor of raw marijuana. He can detect the odor of burnt marijuana. At the time of the stop, he was a certified law enforcement officer. And when he made the stop, he approached the vehicle, smelled marijuana, and there's no indication that the odor that the vehicle was anything but mobile. He saw it moving just minutes prior to the incident. The 2 points of law are really especially relevant here. First, under State v. Goff, that I cited in my response to the defendant's motion, the odor of raw marijuana alone is sufficient to provide probable cause and reasonable suspicion for the search. And the state is not required to show anything more than the mobility of the vehicle to establish exigent circumstances. This is a valid search under the probable cause plus exigent circumstances exception to the warrant requirement, commonly called the automobile exception to the warrant requirement. Also, I believe it suffices for plain view. He saw the medical marijuana bag. He smelled the odor of marijuana. He had lawful access because of the automobile exception to the warrant requirement to go in and seize those objects. And the smell of marijuana is immediately incriminating. Therefore, I believe that 2 exceptions to the warrant requirement are satisfied. This is ultimately a lawful search, and I don't really know that there's any other conclusion based on the testimony.
Mr. Crane, your argument.
Well, yeah, once again, like he also said he seen me going 80 and a 60, but couldn't provide you with a speedometer. So it's like we really just sitting here. And it's just confusing me, like how he's sitting here saying it's air freshener and it's marijuana. It's just too much back and forth confusion, if you ask me, Your Honor. That's not professional of him saying he's smelling air freshener, then he's observing weed and smelling marijuana.
Any additional argument, Mr. Crane?
No.
Okay. Testimony from Trooper McCord is that he was a certified law enforcement officer on June 20th of 24. He stopped a vehicle for speeding 80 in a 60-mile-per-hour construction zone in mile 157 of I-70 which is on the west edge of Hayes in Ellis County, Kansas. When he approached the vehicle, he smelled the odor of raw marijuana and air freshener. The smell of the raw marijuana from the vehicle gives the officer probable cause that there is marijuana in the vehicle, which is illegal. He had observed the car moving, obviously, when it was going 80 miles per hour in a 60-mile-per-hour construction zone. So you have a movable vehicle. The smell of marijuana gives you probable cause to search the vehicle because it's a vehicle. The vehicle exception to the warrant requirement kicks in, and the officer is allowed to search the vehicle. As he asked the occupant for registration, the occupant opened up the glove box. He observed packaging from a dispensary, which also gives him additional probable cause of marijuana being in the vehicle. That would be under the plain view exception. So for both reasons, the officer had the constitutional right to search the vehicle. He searched the vehicle, and your motion to dismiss the possession of controlled substance due to an illegal search is denied. Now, Mr. Becker, the defendant has filed a document titled Defendant's Response to State's Motion to Declare Appeal Unlawful. Are you wanting to, that was just filed on January 21st, 2 days ago. Are you wanting to deal with those issues today or set an additional hearing?
Your Honor, I think I would be prepared. I also filed a motion. I'm not sure if it's gone or a response to his response. So I guess properly I should have called it a reply. But I filed that this afternoon. I'm not sure if it went through to you yet.
That has not made its way into the court file yet.
Okay.
And I know the transcripts that I paid for, I still haven't received those as well yet.
Your Honor, while we're taking this up, can Mr. McCord be excused? I don't believe his testimony is needed anymore.
Yes, Trooper McCord is excused.
Thank you, Your Honor.
Thank you, Trooper.
And Mr. Crane, you had requested some transcripts from the court reporter. You had paid for the transcript from December 9th, 2024.
Mm-hmm.
Okay.
That was supposed to be for our court date before January 3rd, I believe.
And that was emailed to you on January 2nd, 2025.
I wouldn't say I had that in the email because I didn't have that for my court date.
Then on January 9th, you requested a transcript from the January 3rd hearing.
Correct. And still haven't received those.
Okay.
I wasn't sent the link to pay for those transcripts or anything.
You have not paid for the transcript for January 3rd yet.
I know she haven't. I want to say her name's Lyle, if I'm not mistaken. Her last name.
Shock. She sent you the PayPal invoice both on January 13th and on January 21st, and you have not paid for the transcript.
I haven't received those. What does it say? What email she sent it to?
No.
Yeah, I haven't received those, and I had
Well,
told
that you'll have to take up with the
no problem.
court reporter. Okay. Mr. Becker, in looking at the defendant's document, he's titled Defendant's Response to State's Motion to declare appeal unlawful.
Yes, Your Honor.
I think he is referring back to the issues we dealt with on January 3rd.
In large part, yes, Your Honor. I believe that there are also some claims of procedural error, which I addressed in my reply brief, reply to his response. I believe the claims of procedural error are that the state did not respond to his motion to dismiss an objection. And that the court has held him to a motion to suppress that he's never filed. Or as I understand, those are his additional claims of procedural error.
Mr. Crane,
Yes, sir.
would you like to make argument on your motion?
Well, my argument's in my motion as well, but 3, failure of prosecution to follow proper procedure and due process, violation of constitutional due process. The prosecution, well, y'all had just declined my motion, but I had in my motion failures to respond to the defendant's motion to dismiss up an objection violates the principle of fundamental fairness guaranteed by the Kansas Constitution Bill of Rights, Section 10 and the 14th Amendment to U.S. Constitution. Do asserting his rights during the preliminary hearing. Regarding to my motion to suppress, I had never filed that. The failure to address, well, once again, y'all just addressed my motion to dismiss. It further underscores the need for addressing the defendant's legal rights and claims.
Okay. You filed a motion challenging the probable cause at
Yes.
preliminary hearing.
Mhm.
The court reviewed the transcript of preliminary hearing. Court found there was probable cause for count 1. Under the standard of probable cause, was the crime committed, and probable cause the defendant committed the crime. The court found that the preliminary hearing testimony of the officer was sufficient to establish probable cause of identity fraud as contained in count 1 of the complaint. That is the level 8 non-person felony. The misdemeanor in count 2 is not addressed at preliminary hearing because it's a misdemeanor. And the probable cause preliminary hearing, that is a statute that was created by the Kansas legislature. Probable cause hearings are not constitutional in nature. They are created legislative acts. Kansas legislature created the act of a probable cause hearing called a preliminary hearing to deal with felony offenses. The state provided sufficient evidence to bind you over on count 1, the felony. Count 2, possession of marijuana, is not addressed because misdemeanors are not addressed at prelim. Misdemeanors go straight to trial. There is no need for a probable cause hearing on misdemeanors. So the court ruled against your motion to dismiss for lack of probable cause on the felony offense. You then have argued that the state could not add count 3, the speeding infraction. The state can add charges for whatever the evidence supports. And when it's a misdemeanor or an infraction, the state can add that without there being a probable cause hearing. And the state added count 3, speeding, a traffic infraction.
After the fact.
it can be charged up to the jury coming back and concluding the case, as long as it doesn't charge additional charges that you were not put notice on. You've been put notice on for the speeding offense well in front of a jury trial. So yes, the state can add additional charges after the initial charging document.
Okay.
State asked for and received permission to add count 3 at the preliminary hearing. So that motion was overruled. You have
Okay.
asked for the search of the vehicle to be declared illegal. We've just had the suppression hearing. The court has denied your suppression hearing. So that has been denied by the court. You're wanting to appeal the over at preliminary hearing, and you're wanting to appeal, quote, the probable cause of the officer. Those are not appropriate interlocutory appeals under Kansas procedural law. You need to proceed to trial on the case, and then you can challenge those issues on appeal, but not till you have proceeded to trial.
It
They're not subject to an interlocutory appeal.
says right here, interlocutory appeal recognized for substantial rights. Kansas law allows for interlocutory appeals where substantial rights are at stake, as indicated. State versus Johnson, 293 Kansas 543 in 2011.
As indicated in the statute, but the statute authorizes who can file an interlocutory appeal, and the defendant does not have the right to use interlocutory appeal to challenge probable cause at preliminary hearing or a denial of suppression of evidence. The correct procedure is for you to then proceed to trial.
That's going against my constitutional right.
If you are convicted, then you can appeal those issues, but you cannot appeal them prior to trial.
Interesting.
Okay. Now, in your response, that is what you've got down as number 2, legal framework for appeal. Number 3 states failure to follow procedure.
Your Honor. So that's not going against my constitutional right, though?
What's that?
I said, me not being able to
No, the interlocutory appeal, again, is a statutory creation, and the legislature set forth the interlocutory appeal. The defendant does not have the right to an interlocutory appeal on a bind over at preliminary hearing or a denial of suppression of evidence.
Okay.
Okay. Issue 2 or issue 3.1 is your due process, which we've talked about. 3.2 is safeguards under 223208 with electronic communication, which we're having your Zoom hearing at your agreement to do that.
Correct.
3, lack of accountability. Again, you can challenge all these charges at a trial. Number 4, basis for motion to dismiss and current appeal. Count 1, again, you're talking about the identity fraud. The court has found probable cause for that to proceed to trial. Number 2, you're trying to challenge the hearing we just had on the suppression hearing, and that's denied. Count 3, the speeding. The officer does not need to issue a notice to appear at the time. He can proceed with what's called a long form charging document rather than a notice to appear. He added the charge at preliminary hearing and then filed it as count 3, which is what's referred to as long forming it. So you do not receive a notice to appear after they have filed an information or a complaint. They must amend their information or their complaint, which the state has done. So regarding your speeding infraction charge, that is denied. Issue number 5, procedural irregularity. Again, you're referring to the fact that you did not call your document a motion to suppress. What you called your document was a motion to dismiss based on the officer seizing evidence illegally. That is a motion to suppress, which the court has just heard and ruled on. Wanting to postpone your arraignment to proceed with the interlocutory appeals, which you're not entitled to. So that request is denied. Are we ready for arraignment?
The state is, Your Honor.
Mr. Crane, you've got a copy of the amended complaint.
I want to say,
Did they just say?
my mother's gonna grab it for me real quick, but I'm not ready for arraignment. Your Honor, moving forward, could I get all my motions filed under certified mail so it won't be any confusion?
You've already filed your motions and they're in the court file.
Yeah, I got my arraignment right here in front of me.
What's that?
I said I had the journal entry of motion here as an arraignment right here in front of me. That was electronically filed on January 3rd.
Yeah, that's a bind over for arraignment.
Could you break down the word arraignment for me?
An arraignment is when the court addresses what you're charged with and you actually enter your plea. It's a procedural step that begins the speedy trial process. Can you see the amended complaint?
I'm going through.
That was filed on October 3rd.
I'm trying to see where it says October 3rd. It says the 3rd of January.
3rd of October. I'm sharing my screen. Can you see the document?
Hold on a second. No, I don't have this, Your Honor. I don't know why I don't have this.
It was filed that same day as your preliminary hearing.
Yeah, I don't have this.
Can you see it on the screen?
Yes.
In the amended information, it charges count 1 that on or about June 20th, 2024 in Ellis County, Kansas, Caleb Jerome Crane did unlawfully and feloniously alter, amend, counterfeit, make, manufacture, or otherwise replicate any document containing personal identifying information with the intent to deceive. That is identity fraud, a severity level 8 non-person felony in violation of KSA, which is Kansas Statutes Annotated 21-6107, sub B, sub 2, and sub C, sub 2, with an anticipated criminal history score of I. If convicted of count 1, a level 8 non-person felony, you are subject to a minimum of 7 months with no criminal history, to a maximum of 23 months if you have 3 or more person felonies in your background. It is presumptive probation if you have less than 2 person felonies in your background. It is presumptive prison if you have 2 or more person felonies. And a level 8 is also subject to a fine of up to $100,000. Do you understand the potential punishment?
Yes.
Okay.
Question about that though. Trooper McCord said I presented my driver's license. So I'm kind of confused on count one, but
It doesn't have to do with the driver's license. It has to do with the other documents found in the car.
okay, no problem.
Okay? So how do you plead to count one? You can plead guilty, you can plead not guilty, or you can stand mute, in which case the court will enter a not guilty plea for you.
Mm,
So how do you plead to count one?
mute.
So you're standing mute, so the court will enter a not guilty plea on your behalf. As to count two, you are charged that on or about June 20th, 2024 in Ellis County, Kansas, that Caleb Jerome Crane did unlawfully and knowingly possess a quantity of marijuana, a Schedule 1 controlled substance as designated in KSA 65-4105 sub D sub 17 and amendments thereto, and / or its active ingredient tetrahydrocannabinol, a Schedule 1 controlled substance as designated in KSA 65-4105 sub H sub 1 and amendments thereto. Charge is unlawful possession of marijuana, a Class B non-person misdemeanor, in violation of KSA 21-5706 sub B sub 3 and sub C sub 3 sub capital A. A Class B misdemeanor can result in a county jail sentence up to 6 months and a fine up to $1,500. Do you understand what you're charged with?
Mm-hmm.
How do you plead to count two?
I'll plead guilty.
You're pleading guilty to count two?
I'll plead guilty.
Okay. Count three. That on or about June 20th, 2024 in Ellis County, Kansas, Caleb Jerome Crane did unlawfully drive a vehicle at a speed, to wit 80 miles per hour, in excess of the maximum lawful speed, to wit 60 miles per hour, in a construction zone. That charge is speeding. That is a traffic infraction in violation of KSA 8-1558. It is subject to a fine, and because it's in a construction zone, the fine is doubled in Kansas.
And what would that fine be?
Mr. Becker, are you aware of the fine? It would be 20.
I can be in just one moment, Your Honor. It would be a $210 fine.
420.
Is that before or after you?
That is after it doubles.
Okay, so it's $105 and it doubles to 210.
Yes.
Okay. So in count three, you're subject to a fine up to $210.
Okay, I'm gonna plead mute.
Stand mute.
Yep.
Okay, the court will enter a not guilty on your behalf on count three. So as to count one and count three, are you requesting a jury trial or a bench trial?
Can you break that down for me? I don't understand.
A jury trial means we would bring in 12 citizens who would qualify as a jury, and the jury would decide whether you're guilty or not guilty of count one and count three.
And the other one is?
Or you can try it to the bench, meaning you come in and you and Mr. Becker present your case to a judge rather than to a jury, for a judge to decide factually if you're guilty or not guilty versus a jury deciding factually whether you're guilty or not guilty.
We wouldn't be able to do this on Zoom?
No. This will need to be done live whether it's a jury trial or an in-person trial, we'll need to do that live.
Jury.
You'd like a jury trial?
Mm-hmm.
Okay. How long do you anticipate needing for that jury trial, Mr. Becker?
A day, I think, would be sufficient.
I need more time than that.
How much time do you think you need, Mr. Crane?
6 months.
No, we're talking about how long of a trial we're going to have. Not when the trial is yet, but how long of a trial. Mr. Becker is indicating we can do the jury trial in 1 day, in which we pick the jury, make argument, opening statements, present the evidence, make closing statements, and have the jury deliberate.
I say 2 days.
You think it's going to take 2 days? Okay. We'll set 2 days just as a precaution. Jess, we're going to need a 2-day jury trial.
Judge, you would be available on June 10th and 11th.
Can we push that back a little? Give me
Well,
more.
why would you need to push that back?
Just get more time, money. They gotta get out there.
Well, that gives you 5 months almost.
I know I still be having to pay my bills and etc. I wouldn't really, you know what I'm saying?
The problem is we have to get you tried within speedy trial.
Could I
Okay,
get 2 more months on top of that 5?
Judge, it looks like speedy trial's July 22nd.
so we need to get you scheduled before July 22nd, so we don't violate your constitutional right to a speedy trial. Jess, do you have any days other than June 10th and 11th within that time frame?
Could I do July 19th?
Hang on.
July 19th is a Saturday.
Okay.
Judge, you would have time the week of July 7th. You could do July 9th or July 10th.
Nine sound good.
So July 9th and 10th? Does that work for you, Mr. Becker?
Yes,
Or
Your
the,
Honor.
or the 10th and 11th, whichever.
Mr. Crane, do July 9th and 10th work for you?
Yes. What time are you guys thinking?
Well, you'll need to be here. We'll start each day at 9 o'clock, but you'll need to be in the courtroom at 8:30.
So July 9th and 10th?
July 9th and 10th. Need to have a pre-trial 4 weeks prior to that, Jess.
Do I need to be there for that?
Yes, you'll need to be here in person for the pre-trial conference.
Oh my goodness.
June 9th is your motion day. I'm sorry, we're in July. July 9th. Yeah, that would be right. It's about 4 weeks prior.
Now, I know you had some time on June 10th. That's what we were looking at for jury.
Yeah. So your motion day is June 9th. We could put a pretrial there.
Okay, 9th, 10th, or 11th. Let's save the 10th and 11th for other trials.
Right.
Is
Right.
that a Friday?
No, it's a Monday.
You said June 9th and 10th as well?
June 9th
June 9th
trial.
for
What
the
time, Jess?
pretrial. 1:30, Judge.
And I gotta be out there.
Yes, you need
Could we
to
get
be
that a
in-
little earlier or no?
You need to be in person, 1:30 on June 9th for pretrial conference.
I couldn't get that earlier or no?
Earlier in the day, Mr. Crane.
Yes, ma'am.
Judge has time in the morning of that day. You would prefer a morning setting?
Yes, ma'am.
Okay, we could do a 9 o'clock.
And then what time for July 9th and 10th?
You'll have to be here each day, ready for trial at 8:30.
Okay, I'm writing it down.
Judge, do you also want some sort of a status conference prior to the pretrial or?
Yeah, let's make sure we have our pretrial nailed down here.
June 9th at 9 a.m., Judge?
And that works for you, Mr. Becker?
Yes, Your Honor, I don't have anything set out past March yet, so.
And Mr. Crane, June 9th at 9 o'clock?
Yes, Your Honor.
Okay. And yes, we need our motions / jury conference prior to that. So when do you need to send out your notices?
Yeah, will that be in person or by Zoom, Judge?
That one will be by Zoom.
Your criminal motion date for May is May 12th. In that morning, Judge, you would have time?
What time?
9 a.m.
So May 12th, 9 o'clock. That's jury questionnaire and motions hearing.
That will be by Zoom.
That one's by Zoom. If you want it by Zoom, Mr. Crane, we can also do it in person if you want to do it in person.
Could you repeat that for me so I got a clarity?
May 12th, we'll have a hearing to make sure we're using the one-page juror questionnaire or the extended questionnaire, and any other motions that either party has filed prior to trial.
Said either
Do you
motion.
want to do that in person or do you want to do that by Zoom?
Okay, I heard what you said. You said either party's motions and each questionnaires.
Jury questionnaires. Normally we use a one-page questionnaire. If there are special circumstances, either of the parties can request an extended questionnaire, but you need to submit reasons why we would use an extended questionnaire versus the standard one-page questionnaire. And then any other motions that either party has filed concerning the case that need to be heard, we can take up at that time.
Well, yeah, I'll do that on Zoom. What time?
9 o'clock.
Okay, no problem. 12.
We have our juror questionnaire conference and motions hearing, May 12th, 9 o'clock by Zoom. Our pretrial conference is June 9th, 9 o'clock. That is in person. And our jury is July 9th and 10th, and that is also in person.
Okay, no problem. I'm free to go, Your Honor.
Are you still wanting to continue to represent yourself in this matter, Mr. Crane?
As of right now, yes.
Okay. And you believe you have the ability to represent yourself?
As of right now, yes.
Okay.
If I'm gonna hire an attorney, I'll let you guys know.
Let us know, please.
No problem.
As to count 2, you pled guilty. The court will accept your guilty plea. We will address that at the conclusion of the jury trial.
No problem.
Okay? And what I mean by that is if we have a jury, if you are found guilty of count 1, the felony, then you'll have to undergo a pre-sentence investigation, and we will move the misdemeanor sentencing in conjunction with the felony sentencing. If you're found not guilty by the jury, we'll take up sentencing right after the jury verdict. Okay?
All right.
And Mr. Becker, you'll do the journal entry from today?
Yes, Your Honor.
Okay. Any questions you have, Mr. Crane?
Nope.
Anything further for the record today, Mr. Becker?
No, Your Honor.
Anything for the record today, Mr. Crane?
No, Your Honor.
Okay. We will see you then on May 12th, 9 o'clock our time by Zoom for the next hearing.
All right.
Okay. Thank you all.
Thank you.
Be safe, be well, sleep sweet, and much love.